I'm Larry Copenbarger with the law firm of Copenbarger and Copenbarger, and it's my pleasure to spend the next hour with you with Zachary Rayman, who is the partner in Lifestyle Financial Services. And I've had the pleasure for many, many years to work side by side with Zach. And you're going to see as he discusses the areas relating to retirement, maximizing your finances, that he loves what he does. He's an expert in it, and he will stop at nothing to make sure that he meets your needs and takes care of what you need for your family and for your circumstances. Okay, so Zach is going to begin. Well, let me introduce. First, I'll introduce you to who we are as the firm. Uh, Zach is with Lifestyle. He's going to talk first. Then I'm going to pick up and we're going to discuss the Secure Act and some of the estate planning issues that apply to it. At the end, and I'm going to repeat it again, there's a green sheet that you can electronically fill out, identifying comments, questions, and any other issues that you have garnered from this session. Let us know how well we did, whether the time was worth it to you. We're going to do our best to make this beneficial. And of course, we think we know what we're saying, but it's up to you to grade us to see how well we do in communicating what we know. The Copenbarger firm is represented by 10 attorneys, and we have offices throughout the state. We have 44 staff members, and those staff members help us take care of your needs. So as you know, we have offices in the Bay Area, Temecula, San Jose, Sacramento, San Diego, Pasadena, and our main office is in Santa Ana. So Zach, with that said, I'm going to let you pick up where your expertise begins, and let's get them going.
Thank you, Larry. And again, our gratitude at Lifestyle Financial for having a very long-term friendship and partnership with Copenbarger and Copenbarger. For those of you who don't know, we really try to treat all people who work with us like family, and it's a family helping families. Larry's nephew, my partner Charles Sosa, you might know him as Lloyd's grandson, or our firm, Lifestyle Financial founders, Laura Copenbarger's grandson as well. And now we try to continue on this legacy on the financial planning side. And the theme for today's discussion that Larry and I are going to do our best to try to provide people some education is about a lasting legacy, planning that starts today for tomorrow. And as appropriate, a quote from someone, Warren Buffett, also known as an Oracle of Omaha, one of the greatest investors for many people to take insight from, gives little tidbits such as this one. And it shows that you get rewarded for time in the process, not necessarily trying to time the process. Whether it be an estate plan, you want to have everything set up before you need it, just like a financial plan. You'd rather have the plan set in place than you wake up one day and say, oh, I need this plan for tomorrow. Have it already set up. Over the next few minutes, as we dive into financial planning, we're going to talk about a few of the things that are relevant today as it relates to retirement planning and legacy planning from our firm's perspective before Larry will go into the legalities of everything. And then we will do our best to show you how they work hand in hand. So again, at Lifestyle Financial, the partners, advisors are myself and Charles Sosa. A couple of the services that we offer on this page and on the next page. I always like to tell people, if it touches money, odds are we can talk about it. We have a couple of themes that are just good things to keep in mind. As I say, planning is great. You put something on a sheet of paper, and then maybe you put it in your desk drawer and you forget about it for 10, 15 years until you need to revisit it. You want a team in place who's constantly staying up to date, not just on regulations, but the investment climate, the appropriate financial restrictions, or understanding how it relates to an estate plan, the laws regarding transfer of wealth. We do not do anything else. We are wealth managers, we're financial planners and educate. educators. This is our job. I very much enjoy, for those of you who were on early, I was telling Larry that my daughter turns 10 weeks old. I've gotten a lot of practice of waking up at 3 a.m., which is already 6 a.m. on the East Coast. So I'm getting all the early market activity in real time. I genuinely am a nerd for this, and it's a very enjoyable process. I don't think my daughter understands all the market talk that I have, but as she gets older, maybe she'll pick up a thing or two. Now, purposes today are to really hammer in to what is going to be the lion's share of most people's investment planning as it relates to their estate planning, retirement account planning. Now, retirement account planning is not just things that we'll talk about in a little bit greater detail on this slide and the next slide and throughout, but it's money that you start investing today for tomorrow. As it relates to certain accounts, you may be familiar with an IRA or an individual retirement account, or group retirement accounts, most commonly called 401ks, or for certain areas, 403bs. These are all terms and numbers associated with parts in the Internal Revenue Code, or the IRC, which is then governed by the IRS, everybody's other favorite three-letter word, that helps to organize where people can invest dollars today for retirement uses. The short history of this, I'm going to talk about the group retirement accounts first, is in this country, there used to be a lot of pensions. Over the last several decades, we've seen a phase out of pensions and a replacement with 401ks or group retirement accounts, where very simply, you control that account, you can add funds to it, you can select some investments there, and you can dictate more or less the terms while you're employed, how these funds grow, if they go with you from one business to another. In careers, you might start at company A, you might go to company B. Well, these retirement accounts can go with you as well. And then when you are no longer working or employed, you can then, what we call, have a rollover event where you can roll all of these group planned assets or all these funds that you've spent decades building up into an individual retirement account or an IRA. Another thing about an IRA is that you can also start one as soon as you begin employment. They can run parallel or at the same time of a group retirement account. You can have an individual retirement account. If you are able to do both, there are certain pros and cons that you can take advantage of in each type of account. One of the biggest advantages that you can have is the fact that these investments are what many people will refer to as tax shelter accounts. Tax shelter accounts, very basically, mean that you can buy and sell, do trading in these accounts, and you don't have to worry about the tax implications or the impacts of buying and selling an investment while they're in these accounts. It's a very useful tool, especially if you move from company to company and you have to rebalance a very large 401k, for example, into a new company's retirement plan. Or if you have an IRA and you want to buy or sell something specific, or you have a trusted advisory team that's built you a model to go into your IRA with the funds that you have put there, you can buy and sell to take advantage of all the changes that go on in the markets. It's also very helpful to know when and how you can take from these accounts without being too negatively impacted by taxes. Larry will talk a little bit more about some of the changes and the legalities of this, and even how it can relate into your estate planning needs. And then we as a financial team pull from being so legally aware to make the best investment decisions for you. To give you a big specific, today we're in what we call a new investment cycle. We have experienced in the previous investment cycle, I'll just throw out some ranges of times for everybody to visualize, say 2010 to, let's say, February 2020. We lived in an investment environment where there were low interest rates and there was plenty of growth in the stock market. Now, there are many reasons as to why this was the investment cycle, but a couple of the reasons to keep in mind as we transition into today was there was a lot of money in the system. And when I talk about a lot of money in the system, I talk about not just in the US, but around the world. And I talk about the stock market, in terms of companies, could grow to very large sizes. A stock price could accumulate a large number, not necessarily because of profits or revenues or sales, but because of a great idea. And it was very easy to accumulate money. There's no real interest, so businesses could easily absorb all of this. Fast forward, I said, to March 2020. After February 2020, when we hit March, there was a global economic event. I'm not going to pretend to be a doctor or anything else, so I'm not going to go into the details of that. But what is important on a market side is that for a brief moment in time, the global economy basically, if you're to think about this as a car, turned off and went silent for a period of time. And then after a couple of months, someone tried to take their key, turn it back into the ignition, and go directly back to the speed limit that they were previously at. That doesn't work on anybody's car. So there were hiccups and pain points that were caused because of all of this activity, from the no activity into activity, that led to many people's favorite phrases in 2022: inflation, recessionary fears, a cost of living adjustment. These were all impacts from this brief period of time that caused such shakes in the global economic environment. Why is all this relevant to your retirement accounts, to your investment planning for a generation? Well, the stock market doesn't ever have a pause button. All these events kept on getting accumulated in the markets, and we saw massive climbs in certain investment areas, and we also saw pressures or declines in others. Overall, it shook the trees loose and had a reset as to what the investment climate is going to look like moving forward in this new investment cycle. I always tell people history doesn't repeat itself, but it tends to rhyme a lot. And so what we saw is a return to interest rates. You can't live in an artificially low interest rate environment forever. You have to have interest. Businesses can't just go up without profits or revenues or sales. So businesses had to learn financial discipline. They had to make something that we, customers or other businesses, might buy from. In retirement accounts and in plan retirement accounts, all this led to 401k growth, IRA growth, and it was very beneficial that in this new investment cycle, we can still move forward, and there's a lot of gains to be had. On this slide, we now also talk about the type of retirement accounts. I'm basically going to summarize it in two types: pre-tax, or the traditional form of contributing to a retirement account, or after-tax, also called Roth contributions. Originally, you could only put into certain accounts, and there are income limits that we'll talk about a little bit later that would prohibit you from contributing a certain amount into an individual retirement account pre-tax, or the traditional contribution. The benefit of the pre-tax is that you do not have to worry about registering that income for your taxes in this taxable year. It's a great advantage for people who want to pay less in taxes today. And the way that we think about it in the financial planning component, and as it relates to your estate plan, is when is it most appropriate for you to pay taxes? In other words, when can you legally game the system to paying less in actual taxes and have your money work a little bit harder for you? Pre-tax is one very useful option for certain people. You can do this both in an IRA, individual retirement account, or a 401k or a qualified plan retirement account. Qualified just means it's in a tax shelter. That is qualified as it's defined here. The other option is the after-tax or Roth contribution. You're going to pay the taxes at the moment you put the money into the account. You can also think of this on a generational level. Say you're working and your son or your daughter in college or in high school has their first job. Well, for you, you are in prime income years. You might get more benefit having that tax deduction today. So you might want to make the pre-tax or traditional contribution. That's very beneficial. Your child theoretically will be in a lower tax bracket today, and as their careers progress, they'll be in a higher tax bracket. So maybe it's in their best interest to pay the taxes today, make those contributions. And once those contributions are paid with after-tax money, they get to grow after tax. And then for some of you, it might be appropriate to pick and choose, do a partial pre-tax contribution and a partial after a Roth contribution. What our job is to put all that in perspective and help you come up with the right math that makes the most sense based off of your specific financial situation. And we pull a lot from your estate plan to understand the universe of your finances so that we don't just give you a range or a number in an open bubble. We try to put it specifically as it relates to your best situation from a financial sleeve. And there's a lot of protections that are built in place for that. I think it's best also if you keep all these things in perspective, knowing that people are living longer. And as we all know, the world doesn't get cheaper tomorrow. The value of a dollar today is not what it was worth 10, 20, 30 years ago. Our goal is to help you maximize each dollar of the investment. What's your return on that investment, in other words? And for some people accumulating their wealth right now, it's important to lay the bricks or the foundations. And then for others who have established themselves more, maybe it's in the best interest to leverage all the moving components, all the complex parts of retirement planning to get that best advantage. As Larry will talk about the Secure Act, and we talk about larger estates as well, these sort of strategies can help people with large sums of money save and grow more efficiently than they probably thought earlier. And it's very important to have that conversation, to have that knowledge. Knowledge is a great free tool and resource. Larry, I'm going to send it back over to you. We're going to have a Q&A later, as Larry has said, and look forward to your questions. And I'll be periodically speaking, jumping in every now and then.
Oh, all right. Well, thank you, Zach. As you can tell, I feel like I'm 30, but Zach is 30.
33.
And Zach, I guess I was going to ask you a question relating to investments. You're 30, I'm 60. What your needs are they the same as mine in terms of planning?
Great question, Larry. First of all, you could easily pass for probably 35, maybe not next to me in some areas, but
I feel like I'm 30.
yeah. As you age, you have what's called a risk budget. The way that we look to that, and as it relates from our doctrine or your estate plan, we'll then take that and translate that to, in the financial planning world, what your risk budget is. Myself and my wife and our young child, an emerging family, up and coming in our careers and planning on making more as we age, like fine wine to Larry's age, we can be more aggressive now. We have more time. Now, very clearly, Larry, this is a good question. It's not an excuse to be reckless with your aggressiveness. You can take more risk, but you don't want to fly blind or take risk without understanding the returns of that risk. And then when you get to Larry's age, you're a little bit more established. Larry has a better sense of what his expenses will be. He's already shelled out, I don't know, an ungodly sum of money for college and grad school, and medical school, and law school, and whatnot. But your finances between Larry and his wife are more known. So they don't necessarily need to have that same risk return. They want the growth in the market, but they also want the safety net. So he would be not as aggressive or a little bit more conservative than me. If that makes sense, Larry.
It does. Yeah, my wife and I calculated we spent over $250,000 just for our kids' education.
Yeah.
K through 12, not counting college. So, but anyway, that's Zach, thank you. Getting into the Secure Act, it really is covering qualified accounts. So the big secret with IRAs and 401ks, the dirty secret was that they were going to be taxed at some point. What the Secure Act has done to those qualified accounts has accelerated potentially the payout. Well, not potentially, and I guess in some cases it's extended it. So if you're 73 years of age, you don't have to start taking your payout from a qualified account until you turn 73. Zach, is it 73 and a half?
73.
It's 73. So when you turn 73, used to be 70 and a half, where you could start, you were required to take distribution from an IRA, a 401k, or any qualified accounts. With the Secure Act, you now can extend that out to 73. But the secret, the dirty little secret now with the current permutation of the Secure Act is that if you were to die and your qualified account went to a qualified beneficiary, they have a limited window of time to take the payout. And that limited window is 10 years. If they fail to take the payout within that 10-year window, there is a excise tax of 25% on the monies that are not paid out. So it's a pretty onerous impact. There are impacts for you while you're living and you have your IRA if you don't take your required minimum distributions. But that's where Zach and his team come in, where they make sure you never run into the 20% or 50% or 10% excise tax because you failed to follow the rules. So on the Secure Act, what you need to know is its purpose was to raise money and raise it quickly for tax revenue, although when you look at the amount it actually raised, it's $1.5 billion a year, which is a raindrop in a lake compared to the actual debts that we've accrued. But that was the purpose of it. And they've taken away some of the benefits, but they've given benefits. I've already mentioned that if you don't have to start taking payout from your qualified account until you turn 73 now. Used to be 70 and a half. And the good news is in 10 years or 9 years from now, you don't have to take it until you're 75. So it allows the monies to grow at a faster rate. There are some unique provisions for those of you who are higher earners, and you're still in your working age and you're wanting to do catch up on the retirements. They have made it a little more difficult for you, but again, that's something that Zach and his team can cover with you and address it if it applies to you.
Yeah, Larry, if I may just add here
Sure.
too, one of the important understandings is the difference between how the required minimum distribution for people as they hit the RMD age, you get impact in those individual retirement accounts. But say someone still wants to work. And I'm not going to say how old he is because that'd be rude, but Lloyd's older than 73. Lloyd's 401k, as he is still an active participant for the 401k, he does not have to take an RMD from that account. So as we said, people are living longer, and it's not necessarily working because you have to work, more working maybe because you get fulfillment out of it, or your wife wants to kick you out of the house for a couple hours, or vice versa. The benefit of the 401k or an active participant shields you from a required minimum distribution, which is a little known tidbit that we then incorporate to say how if you are actively working and you have to deal with someone's inherited IRA that turns into that 10-year stretch rule, we then try to figure out the investment lineup that also might be the most tax beneficial to when you pull over those next 10 years, that retirement contribution limit, in addition to how it would impact your tax bracket.
Does that provision also apply to IRAs?
Correct. So the IRA is the one where the stretch IRA provision is directly impacting. And then when you inherit someone's 401k, if they didn't roll it over, there's a different impact there, but you still will fall under, if you hit the criterion from the provision, that you have to start taking from that 401k as well.
Well, what I meant was, as you were saying with the 401k, I could be 85. If I'm working, I can still contribute to my 401k.
Correct.
Does that same rule apply to IRAs?
Yes, you can contribute as long as you're working.
Okay, so very powerful tool for those of you who don't want to take your retirement. It's a workaround with the Secure Act. And again, Zach knows the ins and outs, and he can guide you through it. There are catch-up provisions in the law where you can add more if you're over the age of 60. Is that the benchmark, Zach?
Over the age of 50, it triggers what's called a catch-up provision, where so Larry can contribute right now more than I can just based off of age. And a big I'll call it the 30-ton elephant in the room that Larry and I both will lose our wonderful hairlines over, is these laws are constantly changing. So we can give you the numbers. We get updates every year, but we really rely on attorneys such as the attorneys at Copenbarger and Copenbarger who keep to date with the laws, understand how it works, and then we implement the financial plan that takes the best advantage of that.
Well, on the other side of it is Zach and I will help give you the information so you can vote for the right people to make sure that they make the proper adjustments and not continue to make it less beneficial. Is that a fair assessment, Zach?
Yeah, I think the best thing that I can touch on that as I know I can only speak intelligently about finance, but I will say we can provide the understanding to give you what is going to take place, what maybe a side economically stands for an agenda. At the end of this, you'll hear that every participant of these webinars gets a free consultation with Lifestyle Financial. So we give you our political view through the lens of finance. And what I will say is, please vote. I won't tell you who. It's not my job, but please vote. Please understand that that does matter. And each party has clearly outlined certain economic policies that do directly and indirectly impact the financial planning. So to Larry's point, you want to be aware of this and ask us. We have information as to what this looks like on an economic or legal lens for your planning needs.
Exactly. Good point, Zach. Now let's get into how this all applies to your estate planning. For those of you who have trust already in place, it's critical to determine how are your accounts set up? Are they owned by the trust? If their main assets are your bank accounts, your real estate holdings, any businesses you have, investment accounts, how are those titled? If they're titled in your name as trustee of the trust, then they're protected under the terms of the trust based on whatever protections you built into the planning. If you have qualified accounts, IRAs, 401ks, or if you have life insurance accounts, those will be handled by beneficiary designation. And one of the big issues you run into, and Zach will talk about this quite a bit, is when you have an IRA, when you have a SEP IRA or a 401k or a pension, do you name the trust as the beneficiary? Can the trust be the beneficiary? And Zach, I'm going to let you speak to that.
Yeah, it's a good question, and it comes up a lot because you want to have a plan set in place, right? These are in many cases. I'll take the state of California. Your home might be your most valuable asset, but right after that is probably, let's say, your 401k, for example, that you've contributed for decades. There are tax ramifications of directly naming a trust your beneficiary. But if you have the right estate planning instructions and the estate planning attorneys work with the financial advisors, we know the beneficiaries should be people or charity or some combination that you want to specifically list in that account. And it's really important, I'll give a plug, make sure you have up to date your beneficiaries as frequently as is necessary. Sometimes 5 years go by and a beneficiary may pass, or say it's a dear friend who you might have left some money to. Maybe 5 years go by and you're not friends with that person anymore. If the account says something, that's how the money will go. Larry, I know that your law firm has had extensive experiences with the pleasantries of dealing with banks if the titling is not well. The same principle of a bank, which is a financial institution, relates to investment or financial accounts. You need to keep this stuff up to date. It's very crucial to have that information on file. But to directly answer Larry's question, yeah, you can make the beneficiary of a retirement account a trust. There are costs associated with that. It'd be more prudent to know who you want to directly be the beneficiary of, have your financial planner or advisor be aware of that, and give you the education on how to best implement what your plan is with them inheriting those funds. You can have certain restrictions within an investment account that mirror your estate plan. That's the tandem that we work together with. So you don't just there's limitless situations, but you don't just say leave someone a large inheritance and maybe they might not do what you intended those funds to do. If you have that planning set in place on the account level, you'll find that your wishes or intentions are very closely, if not identically matched to the letter of what will be in your estate plan.
Yeah. So, and with the trust, Zach,
Mhm.
you have, I guess you could even do it with a will, but mainly
Yeah,
with trust planning, you can put language in so that the trust can become a qualified beneficiary
correct. And
and
then the
have the
trust can be a
proceeds,
client.
yeah,
Yeah,
and have the proceeds managed under the terms of the trust, but still treated for tax purposes as though it went to the named beneficiary directly,
correct.
which can be very powerful, particularly as we discuss protective language that you may want to consider. And there are also some other negatives of naming the trust as a beneficiary. In fact, I'll cover it right now. Many of you who are our clients will have you name, if you have the proper language in the trust, will have you name after your spouse the trust as the secondary beneficiary. We'll have you name the life insurance as a secondary beneficiary. That can be positive, but you need to keep in mind, had a circumstance this last week with somebody who wasn't a client, but we were talking about it. They have a creditor who's coming after them. Well, if the proceeds of their IRA, if the proceeds of their life insurance had been paid to the trust in the event of their death, the creditor could have gotten those proceeds, which is a reason you need to talk to your legal counsel before you name the trust as a beneficiary of any kind. Because there may be a good reason you don't want it to go into the trust because we're trying to avoid a creditor issue. Zach, have you run into those issues?
We mostly see these sort of issues on the financial lens if things are not titled properly. You know, someone has a trust, but the investment account is a joint account or an individual name account. We can do our best, but sometimes on the investment side or when someone wants to bring a bank account to us, it's not impossible to have an easy resolution to that. You then need to hire Copenbarger to then maybe sue the bank and get your funds that you are entitled to.
Which means we're probably going to go through probate,
Mhm.
which is a proceeding that the accounts we're talking about should never have to go through. So talk with Zach, talk with Copenbarger, and we can help guide you as to how those beneficiary designations should be established so you never end up in a court proceeding, or at least less likely to end up in a court proceeding because you didn't have it set up properly. What are some other things you need to consider? Um, Look at the beneficiaries. Are they capable of handling the money you're going to give them? Do they have creditor issues? Do we have other bankruptcy problems, or is the person able to handle the funds? When you have the proceeds go through the trust, you can help put the people in place to manage it and protect a person from whatever their problem may be. I like to jokingly say sometimes it's the outlaws, the spouses who belong to who your child married. Sometimes it's the in-laws, where you have poor managers, good people, but just don't know how to manage the funds. Um, are we looking at the possibility of divorce? Well, hope not, but you need to plan if that does happen. How are your children, how is the inheritance money you're going to be giving to your family going to be impacted if you have it go directly to a named beneficiary? Within your planning, you can put together language so that that's not an issue. And you can make sure it's handled properly. So your trust, you can decide how the beneficiaries are set up. And so it applies to so it's covered by the Secure Act. What else do you need to consider? What other kind of planning do you need? If your estate's of a significant size, you may want to, if you have life insurance, you may want to consider setting up an irrevocable life insurance trust. You'll hear it said that life insurance is not taxable. It's not taxable for income tax purposes. but it is taxable for estate tax purposes. So literally, if you have an estate that's subject to federal estate tax and you add life insurance on top of that, you're giving the government 40 cents on the dollar of that, quote, tax-free money. One way to avoid that is to set it up inside of an irrevocable trust. 100% of the proceeds can go the way you've directed, and none of it will be included in your estate subject to federal estate tax. If you have a substantial IRA, we have clients who have million, $2, $3, $4, $5 million 401ks or retirement accounts. You may want to establish a separate standalone retirement trust to hold those funds. So it'll be so you can treat the funds as a pension. Again, Zach can address this in the future when you sit down and talk with him. Do we need to modify your revocable trust to add in some of the things we've just been discussing? I didn't call it this, but the remarriage protection, the creditor protection, the divorce protection for your family. Do we have tax issues? Going back to the IRAs and the distribution, do you have children who happen to be significantly successful? I was talking with a client earlier this week. 2 of their 4 children are making $1 million plus a year, and it's not likely to change. These are young folks. They happen to be working with big companies in the Bay Area and down here. What would happen if you gave them an IRA? In the event of their death, the proceeds went to the child. Their income is going to be at the highest marginal tax bracket, no matter how small it is. So you may want to consider modifying your planning so that the IRAs go to the children who are making less income, and then have other assets replace those that are not replace the IRA totals that are not going to the high income child. Still treat them equal, but have the assets allocated differently depending on the need. Do you need long-term care planning? Set up insurances. Do you need asset protection in terms of corporations or LLCs? If you happen to have real estate holdings, particularly in states where you're subject to being sued, you might strongly consider establishing what we call bomb boxes. Another term for it is an LLC, so that the property you have, if somebody's injured on it and it explodes, it won't damage your other assets. The asset being sued is going to still be subject to being taken if you don't have enough insurance to cover it, but at least your other assets are protected. If you have a business, consider separating the assets. So if the business is using a property that you hold, have the property held in its own LLC and have the business lease it so that you're separating the liability. Otherwise, you could have somebody sue the business, take the business assets and the real estate that's part of it, which you never intended to be part of it. And then anything else here. Conclusion. Guys, we're here for you. We're going to allow time. I think we're moving right along in about 45 minutes. Zach, are you free to answer questions for the next 10 minutes?
Yeah.
So Zach and I both will be available to do that. I would like for you to take the time to fill out the green sheet. Oh, Zach, did you want to talk about how to contact Lifestyle and your firm?
Yeah. Thank you, Larry. So yeah, we'll have time for a little Q&A at the end. I know we've gotten some questions that will probably both Larry and I will give you the legal and finance depth a little bit, but as attendees of this event, you get a free consultation with us. There is our main email and our number that goes directly to our home office. We are 30 steps away from Copenbarger, give or take 20 steps in Santa Ana. And we also have our office where I am located in San Jose, Northern California as well. And we do frequently move around to all the Copenbarger locations. So the logistics can work out if you prefer in person or Zoom or a phone call. Just let us know. we're happy to help. And we just want to make sure that we're doing our best to provide the proper education for your specific needs and questions. So Larry, as Larry said, there's I believe the next slide over is a attachment for the green sheet to tell the law firm how they did. Also, you can grade us at Lifestyle. I want to know how I can be better at explaining things. So please do so. And I think Larry, we'll start with some questions. If you
Well,
want to take.
let me add on, we are separate firms, so the appointment with Lifestyle is free, but you also are entitled to an appointment with Copenbarger. And it's just a matter of scheduling that appointment time. And then if you can see on the screen of the digital evaluation, if you'll click on that, I believe that'll allow you to fill in, was this time helpful to you? Was it beneficial? Did you learn a lot? And hopefully you had a good time watching us. And then Zach and I will be here for your questions.
Yeah.
And then Zach, I'm going to let you control the screen because I can't see what you can see.
Okay. You want to just go to the next. So I think there was a question earlier. I'm just going to read off of one that I got about our services. So as I said, everybody here gets a chance to talk to us. If you're interested in working with us, I'll share a little background about myself. I used to work at a small firm called Merrill Lynch. That's usually a joke that I have in person. I have a big bull in my office. But now at Lifestyle Financial, there's no minimum similar to my previous firm. So if the situation makes sense, we're happy to talk and help people have a plan, be put in the right place, make sure that everything's up to date. And I will say, if someone comes in, they just have some questions or they want to have investments in a certain way, we'll make sure that we're the right fit first. It's not just about you becoming a client. We really want you to feel comfortable with the advice and guidance we provide to every advisor here. And I know the same is said for Copenbarger. They just want to take care of you and make sure that you're put in the right place and that your estate planning needs are met. There was a question, Larry, I think you and I can both answer this one. If estate planning and financial planning is the same thing, I'll give a little answer and say there are some similarities. There's overlap, but they are not the same thing. That's we both look probably actually, Larry, we probably look like politicians because we're dressed in suits and we're smiling all the time. Yeah. But my knowledge set and Larry's knowledge set, you could fill an ocean of what I do not know about estate planning law. And I'm sure, Larry, you know a thing or two about finance, but you're probably not a financial professional. You'll bring people over. We complement each other. We're both pieces to the entire life picture. Larry, if you want to add to that.
Well, if it helps, one of the images I'll sometimes use to describe estate planning, particularly trust planning, is picture one of those red wagons, radial flyer wagons you may have had as a child. And on the handle, there's an instruction manual. As estate planning attorneys, we deal with that instruction manual and the wagon. Zach deals with what's in the wagon. And then we help with the instructions as to how those will be managed, coordinating with someone like Zach in terms of what is our goal, what is our vision, who are we trying to protect, what are the needs that we're trying to meet.
Yeah, well said, Larry. Another question that came up was if you have an account not titled in the trust, does the standard Copenbarger pour over will pull it into the trust? Well, Larry, I'll let you talk about what the pour over will is, and then I'll say what I've seen on the investment side in terms of titling.
Well, it's an accurate question. The question was, does a pour over will put it into the trust? The answer is yes, but it doesn't put into the trust the way I think the question infers. The inference I got was that it avoids probate. It doesn't. So if we use that pour over will, it puts it in the trust, but it does it through the legal process we call probate, meaning we're incurring all the expenses, we're incurring all the time delays that you intended to avoid by setting your trust up in the first place. So I may have been reading more into the question than you intended. So short answer, yes, it puts it into the trust, but it doesn't avoid probate.
Yeah. I'll add, on an investment level, if you're thinking about like this, if you have an individual account, I started investing before I got married. And so it was an individual account just in my name. And then when I got married, I had a trust. And then I did the work at my firm it's just paperwork, taking it from an individual account to a trust account. And that just simply means now the account is in the trust. Doesn't mechanically change anything, doesn't mean there's any taxable implications, but everything is now titled the same way, which is really important. And then you never have that issue. We've been doing that a lot lately because more and more of the educations come out that, oh, I have this trust at Copenbarger, I have this investment account, or I have this insurance policy, or I have some real estate comes up every once in a while. We just ask the question, is it in your trust? And we will tell you if it is. We'll see a statement. I can tell in about 4 seconds. So these are helpful conversation topics that then also might help people to understand the protections in the estate plan and the usefulness on the financial lens, what we're looking for to protect your interests.
And let me add one more thing to that, Zach. What Zach just said is critical. The first step is to make sure everything's titled in your name as trustee under your trust. As a secondary protection, with the trust we prepare, at least, we create a listing of assets, a schedule of assets. If you'll keep those schedules up to date, we will not have to probate the asset in the event of your death. We still have to go into court, but it's a fraction of the cost and a fraction of the time that if we had to probate it. So title in the name of the trust first, keep your listing of assets up to date, and then worst case scenario, the will catches everything and puts it in the trust. Now, some of you may be asking, why do we even care about the will putting everything into the trust? We care because some of you have very specialized protective planning in your trust. And if you didn't have the will, you could have an asset go to a beneficiary who needed protection that it wouldn't be protected if it went to them directly, which means it needs to go onto the trust, and that's why the will is so important.
I think the next question is a good one, so I just wanted to pick out this real quick. Larry, I'll let you talk about the relationship that Copenbarger and Copenbarger may have with other clients or the network of attorneys that you can help find in other states in the union. In terms of lifestyle financial, we are licensed to do business everywhere in the U.S. We have several clients in Hawaii and Alaska, all the way to Florida. Maybe not this time of the year, although sometimes a year I would like to travel to spend time in person to those various states, Hawaii and Florida. So we're able to help everybody because we are licensed all across the U.S. And Larry, I'll let you talk about how Copenbarger and Copenbarger, a California-based estate planning firm, though, still can help people even if they're no longer in the state.
Yeah, well, in the law, you have to be licensed in the state you're in for the most part to be able to prepare planning. We happen to be able to prepare planning for clients in Oklahoma, Texas, California, Arizona, and a few other states where we have attorneys who are licensed. But absent that, we do our best to connect you with an estate planning firm who's in the position to help you based on your needs.
Yeah, well said, Larry. And then another question that came up is someone understands that IRAs have people as beneficiaries, not trusts. So generally speaking, on the finance side, and then Larry will provide the legal side. When you have an IRA or an individual retirement account, any type of IRA, I didn't go into detail, but there are many types of IRAs. You want to list people. Now, there are provisions that you can set up on the investment side to help sort of guide how those people become the primary or secondary contingent beneficiaries. And from that, we usually defer to what the estate planning says. And I'll let Larry talk a little bit more about how that works.
Yeah, and in fact, that's a good point. Sometimes we'll have people create what we call generation skipping planning. Despite the way it sounds, we're not skipping a generation for benefit purposes, we're skipping a generation for tax purposes. But the benefit of the planning is it protects a beneficiary from a creditor who might be coming after them. It protects them from a divorcing spouse. It protects their children in the event they survive their parent but fail to survive their spouse. You don't have to worry about the inheritance money going to a brand new family and not the children of your marriage or the grandchildren of the people who intended it to go to the grandchildren. With the proper language in the trust, you can actually name the trust as a beneficiary, as a qualified beneficiary, which would then allow the funds to go through the trust to the beneficiary and not allow a creditor or a divorcing spouse to ever have a claim against it. Does that match what you just said, Zach?
Sounds pretty good to me. Although most of the things that lawyers say sound pretty good to me. I just try to stay out of their hairs. Next question that I thought was good, and I'm just gonna, this is, I think, just for me, regarding how financial advisors get compensated. So I'm known for being blunt, and I apologize to people in advance. We have very strict fee structure. It's on a case-by-case basis. It depends on the assets and what is needed. I always tell people, though, if you're not happy with the quality of service and you try us out for a period of time and you say, Zach, I just don't feel like this cost is justified, you let us know. Because as I say to everybody in finance 101, the client or the household is the boss. I work for you. And so that's how this relationship is built. Having also said that, we set a very fair rate, especially for clients who want the managed or the fiduciary service where we are directly compensated based off of how the assets perform. We don't normally get people who talk about the fees after we start working for them. It's more how much the accounts have grown or how much we're actually implementing the strategy to accomplish the goal of the accounts. So that's on a case-by-case basis, as I said, and that comes into the individual conversation. I don't know, I'm pretty sure Larry, Copenbarger has a very well-established, I think, pricing metric, and they tell you all that up in advance, and I would say that they are pretty good cost of service.
Yeah, for the law firm, we for many things we can tell you what a range of what the flat fee will be. For some matters, it has to be hourly, and it'll be what it is based on the amount of time involved. But for the most part, if you've dealt with us on the estate planning side, after we talk to you to determine what needs to be prepared, we can let you know this is what the fee will be based on our discussions. Zach, there was a question up. I don't know how it came, how I was able to see it, but a person was asking on life insurance and 401ks, is it okay to name a person as the beneficiary? And the answer is yes, but you need to consider, what is your ultimate goal? Do we need to create protection for the grandkids? Does that beneficiary have any creditors or other issues that we need to take into account? Do they have tax issues? And based on the answer to those questions, that would determine whether it's appropriate to go ahead and name the kids or the beneficiary that you're thinking of as the primary beneficiary in lieu of having the trust as the beneficiary.
Yeah, I think there's some similarities later with the example that you gave about that one family that has 4 children, 2 of which have 7-figure jobs. When you have an IRA in the current legislative environment and you inherit it and you are not the spouse or you're over a certain age, minors are exempt from this, minors generally being under 18, I believe, right? I think in the state of California. You then have a 10-year, that stretch IRA provision or the stretch IRA or the 10-year rule where you have to take that account to 0. And every time money comes out of that account, it gets on top of your existing income that you filed for that taxable year. Couple of things that we try to do is the phrasing that I'll say here, even though I don't really want to, is game theory. We try to position from years 1 through 10 the most appropriate year to take what amount you have to take. You can take it all in one moment, or you can stretch it out equally over 10 years, or you can maybe take some in the beginning, more at the end. It depends on the specific situation. Or to Larry's point, if you are the person who has this IRA and you don't necessarily want the 7-figure child to inherit this tax situation, but you want this to go to the family, maybe leave it to a grandchild, or there's other components at work there. The estate plan is the governing document, and then we on the finance side implement that plan. Does that make sense, Larry?
Yeah, and one thing I didn't bring up, but it's critical, is sometimes having the charitable get the qualified monies that are taxable, having them go to charity may be the best use of the funds
Yeah, there's
based
a
on the family circumstance.
yeah.
So definitely take that into account.
Yeah. And then not that we talked about here, but for certain cases, as Larry said, for certain size estates, having a charitable investment strategy is a great tax efficient investing and estate planning tool. And so we can talk about that if the situation's appropriate. I think, Larry, you say maybe one or two more questions?
Yeah,
Or,
to be fair to the people, we told them we'd give them an hour and we've got 1 minute,
okay.
but I'm willing to stay on if they're willing to stay on for a couple more minutes.
Okay. Well, then I think another question that came up, certain specific situations, so we can just play this out regarding inherited IRAs for non-spouse beneficiaries. Someone's done some homework. Very good job. To the point of the RMDs, like I said, you have 10 years to take that account to zero. There's no determinant of when in those 10 years, just at the end of 10 years to avoid those penalties Larry talked about earlier, that account has to be zero. So if you haven't taken any distributions for a year or two, that's not necessarily a good or a bad thing, depending on your specific investment situation or the finances of your household. The best recommendation that we see for people is usually people want to take equal parts out each year. Or if they know, say, they're going to retire and then their income is going to drop after that retirement year, then you start to really take that inherited retirement income.
And a question I see here, Zach, that really goes to you is, can you do financial planning without asset management?
That's a good question. So yes, you can do financial plan without asset management because things, as I said in the beginning, that touch money aren't always stocks and bonds. That's a case-by-case situation where you need to come in and tell us specifically what you're looking for. Sometimes clients who own a bunch of real estate, they still need financial planning and financial management. It's just a case-by-case scenario. But that's a good question.
And then I'm not sure if these questions have been answered already. I know I answered them, but I'm not sure if they heard it. One question was regarding somebody being surprised that the pour-over will went through probate and why is it necessary? Well, the explanation is you want everything to be managed under the terms of the trust. So even though you're probating something, the will makes sure that it's managed under the same set of rules and not have distributions to different people outside of your planning. And then somebody asked about protection. All you need to know is that you have the ability in your planning, whether it's a spouse or whether it's children or other beneficiaries, you can put into your planning provisions that can protect them from creditors, from, as I mentioned, a divorcing spouse, a remarriage scenario where your child survives you but doesn't survive their spouse, and then they end up having a remarriage and have everything go to a new family and bypass the grandkids. Or as a case for a husband and wife, if a husband dies, well, it's more likely the wife dies, is the husband going to remarry? Probably. And if he does, you can set up before he dies, before your wife dies, I should say, the wife can say before she dies, we're going to set things up so that if Bob remarries, we don't have to worry about the resources we spent 65 years accumulating going to Bambi. Instead, it stays in the family. But you have to plan in order to do it. It looks like, Zach, can you see any of the other questions? It says there's one new mention, but I can't tell.
I do see one question. I'm gonna say it out loud to see if maybe it clicks to you, Larry, to make sure it makes sense. But what if you designate living trust as a beneficiary because the bank does not allow title to be in my trust. If I understand this right, it's a difficulty dealing with the bank to put something properly titled. If that is the case, and I apologize if I'm misreading that, this is what I talked about earlier, how banks, long story short, there was this event back in 2008 that many of us remember. It was bad for banks. That's me trying to make a joke about a terrible financial crisis. The outcome of that was that banks got the worst slap on the wrist you could imagine, and they are still in some form of a penalty box. So sometimes banks require, I would argue, needlessly excessive amount of paperwork, notary services, and repetition to change anything on their side to make it compliant with the regulatory environment that they go through. There are pros and cons to that. So if that person has maybe a deeper question that they want to send to the questionnaire service, it can get to me and I'll try to answer that better offline. I just wasn't sure if I answered that right, or Larry, maybe you can add to that as our last question.
I missed it, Zach. For some reason, I didn't hear the details on that.
Basically, the question was, what if you designate a living trust as a beneficiary because a bank does not allow the title to be in my trust?
Then it's one of those things that if the bank won't allow you to put an asset into the trust that can be in the trust, and I say that because sometimes you're mentioning an IRA to them and it can't be in the trust. The law won't allow it, and you don't want it because you'd end up getting taxed. That account can only be the trust can only be the beneficiary. And oftentimes we'll tell you if you're married, you'll name your spouse as the primary beneficiary, and then you'll list the trust possibly as the secondary beneficiary, depending on how the trust is set up. If it's a straight account, a bank account, and I think I've run into one client here in the last 15 years where a bank would not allow them to put an account in the trust. In fact, I think it was last week that I ran into somebody where that happened, but it was one of those online accounts where they wouldn't allow it. In that case, you have to decide how important is it to me to have that account in the trust versus having the bank as the institution where you're keeping the money. If it's critical to keep it in the trust, then ignore the company and go somewhere else. If it's not critical, then go ahead and open the account. Just make sure there's not enough money in the account where we'd have to probate it in the event of your death. And right now that number is anything under $184,500.
I think that's all the questions I see, Larry. Again,
Okay.
Thank you for your questions. Thank you for your time. Lifestyle, thanks Copenbarger for this opportunity to speak to you all. And hopefully if we've given you some advice and guidance, and if you have more, we look forward to hearing from you.
Yeah, and give us feedback and let us know how we've done. Zach, appreciate your spending time with us and giving your expertise. And it's a pleasure. And with that, we'll let you fill out the evaluation. Hopefully you've been doing that. And get back to us. And again, make an appointment. If you see a value to what Zach and I have talked about, take advantage of the opportunity and see if we can be of any service to you. So Zach, I think that's it, and we'll just let them keep access. I'm not going to disconnect it yet. And I don't see any other questions. Okay. Again, thank you guys. Thanks, Zach.
Yeah, my pleasure, Larry. Thank you. Bye, everyone.
All right. Bye.